Hi, good afternoon, everybody. Thank you for coming along to your desks to join us for this webinar, one of the series of short webinars that the immigration team at Goldsmith Chambers have been putting on over the last few weeks. Thank you especially for coming to join us when it is actually an incredibly sunny day for a change outside. I appreciate the fact that you've still set time aside to join us for this, when there are clearly other more interesting or more fun things that you could be doing. I anticipate that the webinar is going to take about 40 minutes, although to be totally honest with you, I haven't fully calculated it. So my apologies in advance if I go slightly over or under that. It's just a general guide so that you know broadly how long we'll be here together for. If you want to have copies of the slides after the webinar's finished, they'll be available and you'll be sent a link, I believe, in the next couple of days, which will give you access to the webinar itself, a YouTube recording of it, which you're free, of course, to circulate to anybody else who you think might benefit from it. So today what we're going to be looking at is mental health issues in immigration cases, particularly looking at how to handle vulnerable clients and the use of intermediaries and other issues to consider when working with vulnerable individuals. And this is an overview of the sorts of topics that I'm going to be covering during the webinar. First of all, I'm going to talk a little bit about how we identify vulnerabilities and areas of concern, and what our roles as advocates are in doing that. And then also looking at assessing capacity, what we mean by capacity, and what to do if you think that, that there is a concern that one of your clients might lack capacity. And then after an assessment's been conducted, I'll be talking about how to facilitate participation from vulnerable clients who've been found to have capacity, looking at best practice and the use of intermediaries. And then also what to do when you've had an assessment that says your client lacks capacity. And in that regard, I'll be looking at the appointing of litigation friends. And then there's just a couple of other issues to consider, and that will be that. So first of all, identifying vulnerabilities and areas of concern. I think it probably goes without saying that it's really important to act as early on as possible if you have any reason to believe that there is a vulnerability or a capacity issue with your clients. And of course, I say that being fully aware of the fact that it may be that capacity issues and mental health issues only arise part way through your conduct of the case. But the important thing to remember is that you have to act as early on as the issue arises or as early on as it's been identified. And that's because a person's vulnerability can affect the case in a number of different ways. Firstly, of course, it can affect the way a client provides their evidence. And that's especially important to bear in mind when you're looking at cases in which credibility is an issue and a person's ability to provide a coherent, consistent narrative and explanation for their reasons for doing things may be held against them. Secondly, vulnerability might affect your client's ability to understand and engage with the legal proceedings themselves. And it's important as well to address that as early on as possible in terms of the way that you even go about taking initial instructions from your clients. And then finally, of course, the obvious one is that vulnerability might affect the factual matrix of the case that you're preparing. And in that sense, what I'm talking about is the way in which, for example, a diagnosis of PTSD might go to evidencing your client's allegation that they were the victim of torture. It's not only in asylum cases that can be a factor. Of course, it can also come into play in entry clearance cases and Article 8 cases. And it can also be a relevant consideration, their vulnerability can be a relevant consideration when you're looking at cases under paragraph 276 AD, subparagraph 1, subparagraph 6, when you're looking at your clients, whether or not there are any obstacles to your client being able to re-establish themselves and reintegrate into their country of origin. And of course, it's important to bear in mind that the nature of the issue that you've identified and the severity of it can also dictate how you conduct your case, both in court and outside. And there's a need for ongoing vigilance in this regard, because concerns may arise partway through proceedings. Mental health conditions that you're aware of may deteriorate during the course of your engagement with a client, and it's important to be reassessing a client's capacity and mental well-being throughout your engagement with them. So in terms of identifying what we mean by vulnerabilities, there are a very broad list of ways in which different applicants or appellants can be vulnerable. Children is perhaps the most obvious one, because by very definition they are vulnerable. Those under 12 are usually going to be in need of a litigation friend to assist them through the litigation process. That's set out in a case of JS and others. We'll mention that case again later on. There are also those with pre-existing medical conditions, and that could include physical disabilities that might require the court, for example, to take into account their access needs. It could be those with a history of trauma, people who've suffered domestic violence or trafficking or torture. Of course, it doesn't mean that everybody who's been through those experiences is necessarily vulnerable, but it certainly should send up a red flag for you and should give you cause to want to tread carefully and to explore whether or not there are vulnerabilities there that really need to be addressed and taken into account. Could also be somebody who's got learning difficulties, either learning difficulties that have been identified by their school or by the local authority, but it could also be simply a suspicion that you have that there might be learning disabilities and difficulties there that haven't yet been explored. Other mental illnesses and mental incapacitation, especially in elderly clients, where you might want to consider whether their ability to retain information and to make informed decisions or indeed recount coherent histories is affected by a dementia or Alzheimer's diagnosis. And then of course there are those with addiction issues. So for example, if you've got a client who comes to you and they always smell of booze or they seem slightly intoxicated, that should send up a warning flag to you to potentially go and get this vulnerability assessed further. And finally, also those who you feel may be under the undue influence of others. And that can be a little bit difficult to identify. But for example, if you have a client who attends with family members to all of their appointments with you, and you get the sense that perhaps they're saying what they think their family members want them to say for one reason or another, that's something to explore further. And it might be at that point important, or it would be important for you to make sure that you are able to have a conversation with your client without those undue influences around. So if they come always with a family member, try to find a way of having a one-to-one consultation with your client without that family member present, to really get a sense of whether the instructions you're getting are coming from your client themselves rather than from the family member. And it may be that you need an independent interpreter in order to do that. And this is a lot to take on, and it's important to also bear in mind that sometimes clients may be not particularly forthcoming. They may feel a sense of shame or embarrassment about conditions that they know they have, and they may also be affected by conditions which they're entirely unaware of. So it really does sometimes come down to you to identify where there's a vulnerability. And it's particularly difficult for us immigration practitioners because so often we're dealing with cases with the assistance of interpreters, and it's sometimes possible for difficulties in communication to be put down to difficulties with interpretation, when in fact there might be an underlying issue there that needs addressing over and beyond the difficulties with interpreting. So there are lots of things to look out for. I've put a few of them here on this slide, but this is by no means an exhaustive list. There is a BSB fact sheet, or there's a series of BSB fact sheets. If you Google those, I think it's fact sheet 2 or 3 that has a table with a fairly extensive list, but again, not a comprehensive one of triggers that may cause you to want to investigate whether your client needs additional support. The examples I've put out there are whether or not you think that your client has difficulty in processing information, avoids eye contact, or repeats everything that's said to them, or whether they seem overly eager to please and to say what they think is expected of them. And the final one I've put down there is to look out for a sudden change in demeanour. So if you've had several meetings with your client and they've come across in a particular way, and then there's a sudden change in their body language or in their pattern of speech, be alert to that, and it may be something that you need to investigate further. And then, of course, there are the more objective outside issues that you might want to look for that would trigger a need for closer investigation, and that would be, of course, the existence of Rule 35 reports into allegations of torture for people who've been detained. Referrals from their GP and GP records in general showing an engagement, particularly with mental health services. If you know that your client's been a victim of violence or exploitation, and there's, of course, if there's been an NRM referral and a possibility of a trafficking claim there, that's also should trigger the need to tread carefully and to look further. But it's also important to remember that in terms of capacity, there's a presumption that people do have capacity unless there's evidence to the contrary. And that's why it's so important to make sure that where there is any doubt, that evidence is obtained as quickly as possible. It's a lot to take in, and it's a lot to have a lot of responsibility on our shoulders, given that we all as advocates are also busy preparing the case. It can seem like a fairly onerous task, given that by and large most of us are not trained mental health professionals as well as lawyers. But nonetheless, that is a responsibility that we bear. For solicitors amongst us, there's the SRA practice note from June last year. That's an updated version of the 2015 one, which says very clearly that you have to be satisfied that your client has capacity to instruct. And if you have any doubt about that, you must do a capacity assessment before you act on instructions. And if you don't do that, you may fall foul of your obligations. And that duty was confirmed in the case of AM Afghanistan from the Court of Appeal in 2017. AM Afghanistan is a really important case in capacity. It's the lead case, I would say, for those of us looking at issues of capacity in the immigration context. I would urge any of you who have a case in which this is a potential issue to go and read AM Afghanistan. It's not a particularly dense or verbose judgment. It's fairly straightforward. It's not too long, and it's a very helpful starting point. And so that's for solicitors. You've got the practice note. For barristers, there's the BSB Vulnerability Good Practice Guidance for Immigration Clients from 2018, which also says that as a barrister, if there's any reasonable doubt that a client lacks capacity, it is our professional duty to satisfy ourselves that the client either does or does not have capacity as quickly as possible. And a failure to do so, again, puts us at risk of falling foul of our code of conduct. So it's not enough for either the barrister or solicitor to say it's the duty of the other representative. The duty applies across the board to representatives at each stage of the process. And it's possible that things are missed along the way, or that issues arise where they weren't before. So it's important for both solicitors and barristers to be alive to their concerns. And for judges, there are similar duties set out in the Equal Treatment Bench Book from March 2020. And actually, that's a very useful document to have to hand, particularly if you're dealing with a case in which there's a judge who seems unfamiliar or reticent to make allowances for investigating questions of capacity. You can find the Equal Treatment Bench Book very easily online as well, and it's, I would suggest, a good document to have to hand. So when we're talking about capacity, what do we actually mean by capacity? Of course, that's one of the first things that we have to look at. And for that, we turn to the Mental Capacity Act of 2005. Section 2.1, it says, for the purposes of this act, a person lacks capacity in relation to a matter if at the material time he's unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or the brain. And it's important to bear in mind that that can be a temporary disturbance or a permanent one. Somebody can lack capacity for a short period of time. The fact that they have been found to be lacking in capacity at some point doesn't necessarily mean that they continue to lack capacity at the key point that you're faced with. Which is why, again, it's an ongoing duty to keep monitoring and keep being alert to changes in behaviour and changes in potential ability to instruct. And there are 5 core principles that are set out in the Mental Capacity Act. And they are, firstly, that a person must be assumed to have capacity unless it's established that they lack it. Secondly, a person is not to be treated as unable to make a decision unless all practicable steps to help them do so have been taken without success. So if there are other measures that you could put in place to help your client better understand legal processes and better understand what's required of them and what input is needed, do that first. And if those steps still don't seem to have addressed the issue, then it might be that, that they'd be assessed as being unable to make the decisions themselves. The third point that the Mental Capacity Act highlights is that a person is not to be treated as unable to make a decision merely because they make an unwise decision. Fourthly, that an act done or a decision made under this act for or on behalf of a person who lacks capacity must be done or made in their best interests. And finally, before an act is done or the decision is made, regard must be had to whether the purpose for which it's needed can be as effectively achieved in a way that's less restrictive of the person's rights and freedom of action. Because of course, a finding that somebody lacks capacity is a very significant one, because essentially what it means is that we're saying that they don't have the authority or the autonomy to make decisions for themselves. And taking that, sovereignty or that autonomy away from somebody is of course a very serious matter that should be approached with caution. Now, the Bar Standards Board fact sheet number 6 sets out some helpful questions for barristers to ask themselves when querying whether there's potentially a lack of capacity. I think these questions are as helpful for legal representatives and solicitors and could be considered at any stage in proceedings. And they are whether the client understands information that's relevant to the decision they're making, whether the client's able to retain that information, whether they can use it and weigh it up in the course of making decisions, and finally, whether the client is able to then properly communicate the decision that they've reached. And if you have a doubt about any of these issues, then I would suggest you need to get the client assessed as soon as possible. A similar test is for the tribunals as set out in the case of Masterman and Lister. But what you need to do, if you've got a concern at all, is to instruct an expert, an independent expert, as soon as possible to conduct an assessment and provide a report. Now, preferably that expert would be a psychiatrist. That's always the preference. However, there are circumstances in which you may not be able to access a psychiatrist in the given timescale, and other circumstances which may lead you to deciding that, in fact, a report from a psychologist, a social worker, or a speech and language therapist is appropriate. And all of those professionals have been identified as possessing the power and the ability to determine capacity issues. And what I would say is that when you instruct your expert, ask for very clear guidance and comment from them. Be specific about the information you want. And it's possible, of course, I'm just going to adjust that slightly. It's possible, of course, that your instructions to the expert may have already been underway at the point at which you became concerned about capacity, especially in asylum cases. As we all know, there are lots of reasons why you might be obtaining a psychiatric report because of its the benefits that it might give in terms of evidencing your client's claim. And if you are doing that, I would say always ask the expert to comment on whether somebody's fit to give evidence, always. And if you've got issues about capacity, be explicit about that as well. And if you've already commissioned a report, go and ask the expert to add on concerns about capacity. You would hope that they would have flagged them up anyway if there was a lack of capacity, but be as explicit as you can is my advice. And then in addition to instructing your expert, consult friends and family members or social workers that are involved with your client. See if you can get a sense from them about any pre-existing issues or identified or not fully pinpointed yet. But get as much input as you can about what it is that might be affecting your client or putting them in the position that they're in. However, having said that, I just want to again emphasize the need to be cautious about others having undue influence. So again, be alive to that. If you're seeking input from family members and friends, just be conscious of the fact that particularly with mentally vulnerable clients, there's a risk that they may be under the influence of others, usually acting in what is believed to be their best interest, but nonetheless affecting the course of proceedings in a way that isn't necessarily isn't necessarily the way that things should be conducted. So just be conscious of that. And then, of course, also go and obtain medical records, medical files, and do all of that as soon as you can, as early as possible, and as soon as you're alerted to the potential risks. There's a case of SB Ghana in which the court was quite critical of a lack of evidence having been provided for allegations that there were mental health concerns. So there you have it, you have your assessment. And now what I want to look at is what happens when you when you receive a report from your psychiatrist which says that your client does have capacity, but is vulnerable in other ways. It's important to bear in mind the ways that that can affect your interaction with them in the run-up to a court hearing, and then of course the impact that that might have on the court proceedings themselves. So if, for example, your client is deemed as being vulnerable because they suffer from mental health issues or mental illnesses, it may be that you need to alter the way in which you take instructions from them. It may be that this is something that the psych report touches on. It would be very helpful if it did. So again, when you speak to your medical experts, ask them specific questions so that they know exactly what information you need from them. They don't necessarily know otherwise. They don't know the nuance of the case, and they don't know in what way their evidence is being used. So do ask them for any particular measures that they advise would assist your client in being able to fully engage and participate with the proceedings. It might be that what you need to do is to take instructions for a witness statement in a different environment, a more suitable environment, perhaps than the one that you'd ordinarily have done. So for example, somebody with particular mental health vulnerabilities may need to be interviewed, is not quite the right word, but instructions need to be taken from them in a quiet place without any interruption, a place that's private without anybody else overhearing or listening in. I would hope that wherever possible that would happen in any event, but I appreciate that many of you are working in offices where that's not always an option. But certainly in these sorts of cases, find a way to give the client the privacy and the calmness and the space that they need in order to be able to fully express themselves. And bear in mind that these things can take time. And I know that that's something that most of you and all of you have in short supply. But what I would say is that taking the time early on to get those instructions right in that initial witness statement can save a lot of time and trouble further down the line. And a further thing to think about is whether or not your client is more communicative at one time of the day than another. And that's particularly in cases where you've got a client who's medicated. So there might be some people who are on antidepressants that leave them rather sluggish at certain times in the day. Be open and invite your client to be forthcoming about that so that you can try and arrange your appointments with them for the times of the day where they're feeling more energized and able and more communicative. Encourage your clients to be transparent about these issues. Invite them to give you the information rather than forming your own assessment of what would be best for them. Input from the clients wherever possible is a good thing. And then we come to the court hearing itself. The obvious place to turn, which I know most of you or all of you probably already do, is the Joint Presidential Guidance Note 2 of 2010 on child, vulnerable adult and sensitive appellants. And there's also the Senior President's Practice Direction on the same thing. And that sets out clear suggestions as to the ways in which the tribunal is obligated to facilitate the effective participation of vulnerable witnesses and vulnerable appellants. And that can be anything from taking a lot of breaks during cross-examination to rearranging the seating so that people's needs are taken on board. The one that we all know is, for example, where there are young witnesses under the age of 18. Often it's helpful for the judge not to sit at the bench, but to come down and sit nearer to them. But there may also be other issues that are slightly less obvious, such as the fact that if a client has a physical disability, let's say they're deaf in one ear, it might be necessary to enable them to sit in a different angle, a different part of the courtroom to make sure that they can properly hear what's being said by the judge and the other advocates in the room. And it might also be that ahead of the hearing, at the start of the hearing or at the pre-hearing review, the lines of questioning in cross-examination can be narrowed to avoid unnecessarily long fishing expeditions, and also to ensure that sensitive issues that are likely to trigger adverse reactions from clients are avoided or minimized wherever possible. A failure by the tribunal to follow that guidance note is likely to amount to an error of law, but of course that depends on you being able to show and to demonstrate that the guidance note was not followed, and that it was abundantly clear that it ought to have been applied. So if you have a case in which a client has these vulnerabilities and you instruct counsel, for example, in the appeal, make sure you get a note from counsel, a detailed note, or in some circumstances it might be appropriate to even take a witness statement from counsel highlighting the tribunal's failure to adhere to the presidential guidance note, and that will be helpful then when it comes to drafting of grounds of appeal. Again, preparing in advance, always preferable, often not possible, I appreciate, for all of us. But wherever these issues are on the horizon, raise them at the CMR. Even if you haven't yet conducted a psychiatric assessment, put the court on notice that there are issues that are being explored, because the court's more likely to be flexible further down the line if they've already been alerted to the possible existence of areas of concern. So in extreme cases, where a client is found to have capacity but not but is unable to fully communicate or fully understand what's going on, the court might be best served by the appointment of an intermediary. Now, the Equal Treatment Bench Book has this to say about intermediaries. It says that intermediaries are impartial, neutral officers of the court. They're not expert witnesses. Their job is to facilitate communication between all parties and to ensure the vulnerable person's understanding and participation in the proceedings. This includes making an assessment and reporting orally or in writing to the court about the communication needs of the vulnerable person and the steps that should be taken to meet those needs. So that's really important to remember, that an intermediary is an expert, but not an expert witness. They're often speech and language therapists by training. What they're not is family members and friends of your client. That is a role that, the role of litigation friend, which we'll come on to shortly, is one that those people can fulfill. But where a client has capacity but requires an intermediary, it needs to be a professional intermediary who's appointed. Social workers are also not appropriate intermediaries, and one of the reasons is that the intermediary needs to be independent, and the social worker that's been working with your client is not independent. So when an intermediary might be needed, if your client, as I said, has capacity but really struggles to understand what's happening, it might be that one is needed. They're quite common, I believe, in criminal cases. I don't practice in criminal law, but I understand that they're quite common there, and sometimes in family cases as well. But they're not very commonly used in the immigration context, but they can also assist the tribunal. The most helpful reference for you, if you're interested in looking into them more, is the Advocates Gateway Toolkit number 16, which addresses intermediaries. It's drafted with intermediaries in the criminal context in mind, but a lot of the points in it are equally transferable to the tribunal. So what happens if you have a psych report in which your expert has recommended that an intermediary be appointed? What do you do? How do you go about instructing one? Well, the first thing you need to do is to inform the tribunal as soon as possible, either in writing or at a case management hearing, preferably both, and let them know that there has been an independent expert assessment which has recommended their appointment. And then you'll need to contact Communicourt, which is the independent charity that provides court intermediaries. And they will need to conduct a preliminary assessment of your client, sort of like a psychiatric assessment, I believe. And they will then form their own view as to whether or not their services are likely to assist your client, or whether in fact there's little that they could do to add or facilitate your client's engagement with the hearing. The tribunal can issue directions for a Communicourt intermediary to be appointed. They have that power, and the funding lies with the tribunal. There's no legal aid authority funding for this. It's an excluded disbursement. In much the same way as court interpreters are funded by the tribunal, because they assist the full participation of court users with the tribunal service, so the intermediaries are considered a reasonable tribunal disbursement, because they too are officers of the court, and they're there to make sure that everybody who's participating is able to do so fully and properly and engage in the best way possible. The first thing that will need to happen, if you get a report from the intermediary confirming that they are able to assist, is that your judge will need to set down what's called a ground rules hearing. It's in essence, more or less the same as a CMR, but there's the presence of the intermediary as well. Your client doesn't need to be there, and I would go so far as to say it would be better if your client wasn't there for the ground rules hearing. But at that hearing, the court will hear from the intermediary, who will already have conducted a preliminary assessment, as to what measures need to be put in place for your client and the role that the intermediary anticipates playing in proceedings. It could be that the intermediary is of the view that they are only needed for part of the hearing, not all of the hearing, to assist your client, maybe if your client is giving evidence, but not in other ways. It could be that the intermediary is of the view that your client needs their help throughout. And if that happens, then the intermediary will be there to ensure that your client fully understands everything that is said by everybody in the courtroom. And to that end, it might be that you're requested to send through to the intermediary a list of all the questions that are going to be put to any witnesses, not just to your client. And that's sent through confidentially. So the Home Office, for example, wouldn't see your list of questions. Likewise, the questions that they want to put in cross-examination need to be sent through to the intermediary, but not to us as appellant representatives. And then the intermediary will attend the substantive hearing, and then they're there throughout the hearing and able to intervene if they find that your client is not fully understanding what's happening, or to rephrase questions that are put to your client, or indeed questions that are put to other witnesses, because of course it's also important that your client fully understands what their witnesses are saying in the course of their own hearing. So it may be that even if if you decide that actually your client's own oral evidence isn't needed, there can be lots of reasons for that, of course, but if you decide not to call your client to give evidence, it could still be that the intermediary would be of assistance there in the courtroom, helping them understand the rest of the things that the other witnesses are saying, and of course what the judge is saying to them. Now, one thing that I've seen is intermediaries recommending that they be present when instructions are taken at the solicitor's offices for the witness statements. So again, another reason why it's really important to identify as early on as possible whether or not there are issues that could give rise to the need for an intermediary. If you've already taken witness statements from your client, what the intermediary can do is to be present at a readback to make sure that the client really does understand what's written. And they can work alongside interpreters, of course. It means that the hearing might go on a little bit longer because everything's being said more than they wouldn't, been broken down more often and being repeated in different ways by different people. But the court intermediaries are professionals. They're used to dealing with court hearings in which interpreters are also used. But as I said earlier, one of the key things to remember as well is that a report from an intermediary isn't expert evidence that you can rely on. Of course, the fact that you need an intermediary for your client in the first place is likely to be significant in that it points to a vulnerability or a difficulty that the client evidently has. But you can't rely on the substance of the intermediary's report as evidence of mental health issues. I don't anticipate that would ever really be much of a problem, because the likelihood is that if you've got to the stage of instructing an intermediary, you've already got your psychiatric report anyway. But it's just important to bear that in mind. The intermediary's report can't be evidence for you in your case. So that's dealing with clients who are vulnerable but do have capacity. I'm just going to look briefly, because I realise that I said I'd be about 40 minutes and I'm already ever so slightly over that. So thank you very much for bearing with me. There's not much more to go, but I just want to touch briefly on what to happen when your client is deemed as lacking capacity. And it's important to remember that not being fit to give evidence in court is not necessarily the same as lacking capacity. So a client may be assessed in their psychiatric report as not being fit to give evidence or even attend court. But of course, that it may be that they're able to provide instructions in a more relaxed environment of your offices, with fewer stressors, and over a prolonged period of time, that's not the same as lacking capacity. Lacking capacity is, well, I'll come on to that in a moment. I'll stick to the slides. AM Afghanistan again confirmed the earlier High Court case of C, which said that there is a broad power and flexibility in the tribunal to appoint a litigation friend in cases where someone is found to lack capacity, but that power needs to be exercised with caution, because the implications are serious for your client, because it means their autonomy in terms of their decision making is going to be taken away and given to somebody else. Family members, friends, social workers, very rarely solicitors, can be appointed as litigation friends. If you've got a client who you think would benefit from having a litigation friend, or who needs a litigation friend because they don't have capacity, but who doesn't have a support network around them or anybody that they would, who would be suitable, there's an organisation called Migrants Organise, and if you go onto their website, there is a project that they have, and they claim to be the only one in the country that does this, that compiles a database of independent litigation friends who would be willing to support your clients and help facilitate their immigration cases. So what is a litigation friend? The litigation friend essentially directs proceedings. They take decisions about your client's case, as long as they're decisions that are being taken in the client's best interests. They are expected to try to explain what's happening, to talk the case through with your client, to ask for their input in terms of their wishes and feelings, and to let that inform to a degree the decisions that they're making. The litigation friend will talk to you, their representatives, on behalf of your client, and it will be them that you get your instructions from. And it's important, if you do bring on board a litigation friend, that they understand that if any costs are awarded against your client, it's them that stands to pay those costs. It's them that would be required to pay them. And so when you consider whether or not somebody's an appropriate person to have as a litigation friend, you need to consider their suitability. You need to look at whether or not they've got any conflicting interests. As I said earlier, that might be cases where you think possibly there's a family member who's influencing your client over and above the norm, or where you think somebody has a slightly ulterior motive or interest, their own interest in the case. They're probably not appropriate to have as litigation friends. And in some cases, social workers may be put forward as appropriate litigation friends. And in that regard, you just have to be alive to the potential for there to be a conflict of interest between the local authority and your child client. Of course, that's especially so in age dispute cases. So litigation friend needs to have no conflicting interest, and they need to be someone that you think can make decisions in a fair and competent way. And unfortunately, the responsibility for making that assessment falls broadly with you as the legal representatives. There's another helpful case of JS, which looks specifically at when to appoint litigation friends for children, but it's also helpful guidance for adults as well. And again, in that case, they highlighted the potential for social workers to take on the role of litigation friends for children. But I would again urge you to exercise caution in that regard. It doesn't mean that a social worker is never the right person, but it's certainly something that you need to consider quite carefully. And in the case of JS, the tribunal confirmed that the relevant part of the CPR, which is part 21, which governs litigation friends in the civil context, it doesn't quite directly apply to the tribunal, but it's still a helpful guide. So it's a good place to turn to. But the forms that are required to be filled out under the CPR are not needed in the tribunal. There aren't any prescribed forms that you need to complete in order to get a litigation friend on board. What you need to do is, again, contact the tribunal and ask for the tribunal to issue a direction that the litigation friend be appointed. And as a best practice guide, what I would urge is that you take a statement of truth from the person before they are brought on board as a litigation friend. Unfortunately, it's still a very grey area. There's a lot that's not set down in stone, and so much of it will depend on the specific circumstances of your case. It's really something that has to be looked at on a case-by-case basis. There is a need for clearer guidance for the tribunals on this, and that's something which was highlighted by Lord Justice Underhill in AM Afghanistan when he pointed to the need for the Tribunal Procedures Committee to issue guidance on this point. That hasn't happened. I think AM Afghanistan was 2017. It's likely that something will be issued before too long. So if you have a case where this is a feature, just do a bit of Googling beforehand and see whether there's been any clearer guidance issued in the interim. So just finally, further issues. I just want to emphasize that, I just want to emphasize that if you have a vulnerable client, whether they lack capacity or they have capacity but they struggle with communication and understanding the litigation process, it's really important that you go and try to support their case by finding evidence in other ways. One of the obvious things is to take statements from other witnesses, and that's regardless of whether or not your client's going to give evidence in court or not, but witnesses that can corroborate their account. And if their vulnerability is a factor in the case in and of itself, then it's particularly important that you go and evidence it in as many ways as you can, through obtaining GP records if they've been involved and engaged with their general practitioner, if they've had any other medico-legal reports, if they've been detained, if there's a Rule 35 report, and so on. Try to support their case in as many ways as you can when it's clear that they're not able to provide you with all of the information that you need. The UNHCR, my final point is that the UNHCR handbook is very helpful in that regard with it when it comes to asylum cases. The handbook says it's important to lighten the burden of proof normally incumbent on the applicant by trying to evidence and support the case in other ways. So please do bear that in mind as well. That's it. I hope that's been helpful. I hope I haven't gone on too long. If you've got any questions, I'll happily take them now. You can also, of course, email me at any time. I'll also just flag up that we've got other seminars, webinars coming up. The next one is on Thursday, same time, 3 o'clock. My colleague Jane Haybrook is going to be doing a webinar on Afghan asylum and protection claims and all of the key things to look out for in preparing those specific sorts of cases. So please check that out as well. Now I can see that there are some questions, but I can't access them. I'm a bit of a rookie when it comes to this, I'm afraid. I've got my colleague Lawrence Yusefian, who's very helpfully facilitating this webinar behind the scenes. You can't see him, but he's there. I wonder, Lawrence, if there's any way that you can help me in trying to find out what these questions are. I don't think I can access them. I'm not quite sure where that is. I can see that there are 4 there. I think, given that we've been going on quite a while, what I'm going to suggest is that I don't take those questions now, but I'm eager to try and answer them where I can. So those of you that have just sent a question through, could I ask that you just send through into the chat your email address so that I can respond to you at least individually in that way? That would be really helpful, and I'll do that as soon as I can. Sorry, that's my my technological inefficiency there, or incompetency, letting me down at the last minute. So I think we'll leave it there. Thank you very much for joining us, and look out for the other seminars that are coming up in the next few weeks, and hopefully you can go out and enjoy some of the sun. Bye.